back to his house to see if he can get another computer to
Okay.
operate.
I think we're just waiting for Mr. Bush still. Is that correct?
Correct.
Okay. Ms. Mazzoni, do you know anything about your lawyer for this morning?
Yes.
And you're on mute, ma'am.
Yes, Judge, I sent an emergency motion. Did you receive it?
No.
Well, system took it.
Oh, that's not how we get courtesy copies, ma'am.
I sent it to, I don't know, I sent it to email to Mary, she knows very well, and to everybody.
No, I haven't received anything this morning on this case.
I
from
sent it
Nairi.
on Friday night or Saturday night to Nairi, to both lawyers. So Mary is sitting there and acting like she doesn't know anything.
You shouldn't attribute things to people when they're not saying anything, ma'am. But no, Nairi has not sent me anything on Mazzoni since before our first hearing, when I got many courtesy copies of documents. I can check with Nairi to see if she has something.
And the system accepted that as well. My lawyer is not going to be here. It's all an emergency motion that I sent on by myself, and system accepted it.
I'm sorry, Your Honor. Did you want to go on the record?
Just a moment. Let me first, I'm going to put myself on mute and stop video, and I'm going to call Nairi.
Алло.
Yeah. So just no.
Все на тихом сейчас, они ждут, судья рассматривает, и я на этом, на мьют.
Окей, ты на мьюте. Значит, просто оставляй его так на спикерфоне, потому что его компьютер запишет. So does your computer will record for audio from outside? Let's say Olga will.
No, but I'll record on my phone and I'll put them together.
Okay, so he'll record on his phone and then she'll put it together. Okay, but not yet because judge is considering whatever she's.
They didn't see my emergency motion. They didn't see it, and I heard when I logged in that his lawyer was saying that somebody broke into Anthony's computer and they want to put it on record, and they think, you know.
Listen, you object to that? They haven't
I-
introduced any evidence. There is no evidence.
I didn't broke in. Dan, I don't freaking know how to do that.
Listen to what I'm telling you. This is what you tell the judge. You're objecting to anything being put on the record regarding a computer that may or may not have been broken into. You have no involvement. They have not introduced any evidence, and you want that stricken from the record.
And they put it before I even
Listen,
like.
I don't care. Listen, just tell
No,
the judge
Dan.
that.
When I was
Remember
logging in, I heard them saying that they want to put it on record. I was not even logged in half.
Still, Ola, you heard them say it, so write it down right now because you'll get nervous and forget. So write it down. Your Honor, I heard that you want to put it on the record.
I heard opposing counsel state that something about a computer being broken into it, and they want to put it on the record as if insinuating that, or stating or claiming that it was me. I want that stricken from the record. There's no evidence of that, and there's no evidence that the computer is even broken into. They haven't introduced any evidence, and I do not. I want that stricken from the record.
Are you writing it down, Ola?
Я знаю, что сказать. I will tell that. I'm not gonna get nervous and forget. That's the first question I'm gonna ask right now. But
You want it stricken from the record. You absolutely object to anything regarding that computer being broken into, whether it was or was not being put
they're
on the
not
record.
saying it's not me. They just said that they have computer broken into. How about what if I say that I want to put on the record my computer been broken into as well? I'm gonna say that. That's what I'm gonna do.
No, you're not. You're just simply going to say you're objecting to anything regarding the computer being broken into that has nothing to do with this case.
Well, how about I'm gonna say my phone been broken
Don't
into?
act like a child and respond like, oh, my computer got broken into. No. Stick to the law. Stick to what I said.
Okay.
Your Honor, I heard something said about a computer being broken into and getting that on the record. I absolutely object. Whether a computer has been broken into, we don't even know if a computer's been broken into, and it has nothing to do with this case.
Yeah, that's fucking bullshit. This is already games again.
I understand that. That's why I'm telling you to say what
Okay,
I'm
then
saying.
I
The
got
way
it.
that
Okay,
I'm
that's
saying
it. Tell me you cannot hear me from my
No, I can't hear you, but I can hear the rest of it.
Why is that? What's going on?
I don't know. I gotta look at it afterwards. But we can't fix it right now. So
I'm just saying maybe it's not even recording my responses either.
I don't see. Make sure that
Don't
this is
unmute
not
right now.
what we're talking about now. You know.
Yeah. I am on mute. When they go now, I stopped it. Look, everybody stopped because judge is looking at it. Okay, she's back. Okay.
Okay, everyone, if you could please rejoin me.
Hold on.
Ms. Mazzoni, if you could please rejoin me. This is Judge Walker.
Judge Walker.
Ms. Mazzoni.
Ms. Mazzoni.
Then they can hear everything. It's like echo. I have to stop the phone call.
Ms. Mazzoni, there you are.
Yes, hi.
Okay. Ms. Donnie or Mr. Howard, could you please make the record for today, open the record with the case name, et cetera, and caption?
Sure, I can do that. This is in re the former marriage of Anthony Mazzoni and Olga Mazzoni. It's number 2011 D7317 that is consolidated with 11D7189. For the record, I'm Mary Donnie, the child representative. Also present are Mr. Howard representing the petitioner Anthony Mazzoni and Ms. Mazzoni, the respondent. Mr. Bush is not present.
Okay, I have just spoken to the court coordinator, Nairi Hagopian. Nairi advises that Ms. Mazzoni sent on Saturday an unfiled motion.
No, I
that
filed
it-
the motion. I can show you where it's accepted.
Ms. Mazzoni, please don't interrupt me, okay? That she sent an unfiled motion to Nairi. And it says something about how she's basically firing her attorney. However, this court has not received a motion to withdraw from Mr. Bush, which is required. And Ms. Mazzoni has not filed a supplemental appearance. And therefore, it would be improper for this court to proceed today to conclude Ms. Donnie's cross-examination of this witness and to conclude the hearing that the court started on, I believe it was October 25 and 26th. So we do have another day set aside for hearing on this case, which is next Tuesday, the 16th. By that date, Ms. Mazzoni, in order for us to complete this hearing, you will need to have your attorney file a motion to withdraw. If in fact he is no longer your lawyer, that needs to be done. I can't proceed when there is an attorney's appearance on file without that attorney present. So that will need to be perfected, and you, ma'am, will need to have filed your supplemental appearance. And then you will need to have to make sure that the copy of the motion that you forward to the court coordinator does bear the court's, the clerk's filed stamp. So those will be the things you will have to do to perfect.
Well, I filed it. I e-filed it.
Again, ma'am, you're interrupting me. Please don't interrupt the judge ever. That's not a good idea. I will call on you to speak when I'm finished. So again, ma'am, those are the three things that you will have to perfect. You have to file to send to Nairi a filed stamped copy. It's not sufficient for you to say, I filed it with the clerk, because you see, the clerk is an entity unto its own. Although it helps the court by entering orders and sending orders to litigants, it does not reflect anything with the court. The clerk does not give the court courtesy copies. So even if you did file it, you will need to perfect your motion by sending the filed stamped copy to Nairi so that she can forward it to me. And again, in addition to that, there needs to be a motion to withdraw filed by Mr. Bush. I cannot proceed without it. I have to see his motion to withdraw and grant his motion to withdraw before we can proceed. And then finally, ma'am, you will need to file your own pro se, meaning on my own, supplemental appearance with the clerk and send that as well to Nairi. Do you understand everything, ma'am?
Not everything. I have questions.
Okay, go ahead.
So Ted is not replying, and before, you know, his condition, so he's not replying really, and I cannot make him to withdraw. So that's why I filed the motion on my own. I haven't received, I filed, it showed me that it's been e-filed, so I basically have to get them accepted. To do that, I have to call them, I guess, or I don't know how it works. That's my question to you, because I e-filed it and it says motion accepted on my email.
Yeah, I have no idea, ma'am. Again, I don't work for the clerk's office. I have no idea the machinations of the clerk's office, but I believe that when you file something with the clerk's office, you get a filed stamped copy from the clerk that you then can forward to Nairi.
I didn't get any copies.
Okay, I have no idea, ma'am. You might have to go to the courthouse and get it. I have no idea. But the bottom line is you have to send a filed stamped copy to Nairi. I have not even read anything you've filed today. And these things will have to be perfected by getting them to me in proper format. And you will, Mr. Bush has certain professional obligations under the Code of Professional Conduct. If in fact you have fired Mr. Bush, he knows what his responsibility is. He needs to file a motion to withdraw based on the breakdown of your relationship.
There's
And
no
again,
breakdown of relationship. It's the he's sick.
Okay,
It's not
well, then he would need to file some type of a motion with respect to delaying the proceedings until he is better, or whatever the case may be. But the case remains as it is, status quo, until I figure out what he's doing. If he needs a delay in the proceedings because of his illness, then he simply needs to file that motion. If you have fired him, he needs to file a motion to withdraw. He will know what his professional obligations are under the Code of Professional Conduct. But those things need to be perfected. We cannot proceed today. It would be highly proper for me to do that. Mr. Howard, you had your hand up.
Well, I was just going to point out to the court, if the pleading has been accepted, then Ms. Mazzoni can simply download the pleading. There's an application there to do that. Download it, save it, and forward it to everybody for the file stamp. So that should be relatively simple, Judge.
That's what actually good thing. I was gonna ask. There's 2 lawyers sitting there, and every time there is a court, Mary always tell Anthony what to do. She's telling, oh, he's there, he's here.
Again, Ms. Mazzoni, I don't know why you're talking about such things.
Because I need help as well. Why Mary doesn't help me?
These lawyers don't represent you.
They represent him then, especially Mary. That's interesting.
They don't have to help you because you're not their client.
Then tell me why Mary is helping Anthony every time before you came on a case.
Again, Ms. Mazzoni, these comments do not add anything to our proceeding today. And I'd ask you not to make these comments. It reflects poorly on you, actually, to be constantly castigating Ms. Donnie. It really reflects poorly. So you do better for yourself if you didn't make such comments. Ms. Donnie, you have your hand up.
I do, Your Honor. When we were, Mr. Bush did not appear, I sent an email to him. And then I went on the Illinois, as an officer of the court, I went on the Illinois ARDC site. And based on my review of the Illinois ARDC site, Mr. Bush has been suspended from the practice of law as of November 4th. We have not received any official notification. I have not received any response to any of my emails, but there is there was, my research, I just did it briefly here this morning as I was sitting here. It shows that he's on an interim suspension. And so that was as of, let me lower my hand, as of November 4th. Prior to that, he was licensed, so I don't have a copy of the petition for interim suspension. We tried to get it, but it was filed on November 4th, so.
Okay, Galaxy Note Fan Edition is Mr. Mazzoni, is that correct?
Yes, Judge, it is, and he just signed on.
Okay, I'm admitting him. Does anybody know someone named Attorney Marco Rodriguez?
No.
No.
Ms. Mazzoni? Ms. Mazzoni?
No.
Okay. He's in my waiting room as well, Attorney Marco Rodriguez. I'm going to admit him and tell him he's in the wrong place. One moment. Good morning, Mr. Rodriguez. I admitted you simply to let you know that I believe you're in the wrong place. This is Judge Deborah Walker, and the only matter I have set for hearing this morning is the Mazzoni case.
You're right. I'm before Judge Powers. I apologize.
Okay. Good luck to you.
Thank you.
Mr. Mazzoni, have you joined us? You're on mute.
Yes.
Okay. And your counsel can bring you up to speed, but the bottom line that we've just learned by Ms. Donnie's research while we've been dealing with this matter is that Mr. Bush was suspended from the practice of law on an interim suspension on November 4th. And Ms. Mazzoni sent to the court's coordinator an unfiled motion on Saturday. She indicates that she has not fired Mr. Bush, but that she wishes to proceed on her own today. And I've told her that procedurally, I can't do that. Now, this does shed some new light on the whole situation. So if in fact he's been suspended, does anyone know, is he a sole practitioner?
Yes, Judge, he is, as far as
Okay.
we know.
Okay, so I haven't really been confronted with a situation where I had an ongoing case with a lawyer who's been suspended.
I was just trying to think of that. I think he works from his home. And so I don't believe he has any associates or anybody else that I've ever seen appear with him or.
Yeah, so there's no one who can file a motion to withdraw then. Because if he filed a motion to withdraw, that would be practicing law while he was suspended. And if he doesn't have any associates who would file that on his behalf, then I guess I would just take judicial notice of the interim suspension. I should look at it myself, I think.
Yes, Your Honor. And I'd be willing to call the ARDC to see what the procedure is. I'm sure there's attorneys that they have a procedure that the ARDC has set forth. I just don't know what it is. Some kind of notice.
What's his first name? Is it Edwin?
It's Edwin.
Yeah. Okay, I'm on the site right now, so that you guys can prepare an order for me for today. Okay. Edwin Franklin Bush III.
Correct, Your Honor.
Des Plaines, Illinois.
Correct.
Not authorized to practice law due to discipline.
Correct.
His last registered year was this year, 2021. Okay. Okay, so I've seen it with my own eyes. I'm taking judicial notice that Mr. Bush has been temporarily suspended from the practice of law. So if you could put that finding in an order for me. And therefore, I will not require a motion to withdraw as counsel because to our knowledge, he does not have a colleague who could file that on behalf of his firm. I do still require from you, Ms. Mazzoni, that you forward to Nairi a filed stamped copy of the motion you sent to her on Saturday, and that you file your supplemental appearance, pro se appearance in this case, and send her a copy of that as well. So you would need to, I will give her leave of court today, Ms. Donnie and Mr. Howard. I will give her leave of court to file her supplemental appearance. Ms. Mazzoni, it should not cost you anything to file your supplemental appearance because your lawyers would have already paid the appearance fee on your behalf. But you do have to perfect that to be properly before the court to represent yourself in this matter. And ma'am, is it your desire to go ahead and proceed next week representing yourself?
I never said that, and I was gonna ask for a time to find a lawyer. I guess I can't represent myself.
You can or you cannot. I didn't hear what you said.
I don't want to represent myself.
Okay.
So I need time to find another lawyer. Plus, I still need to see my son, and I haven't been able to see my son in between this time because who knows how long it's gonna take. You know?
Yeah, that's unfortunate, ma'am, but I can't do anything about that. We're in the middle of a hearing on that very subject matter. Mr. Howard, you have your hand up. Do you have an objection to me giving her 21 days to find another attorney to find a supplemental appearance?
I don't have an objection, Judge, but we have kind of a procedural conundrum.
Yes.
Ms. Mazzoni is under orders of this court not to speak about the case. Now, this is an exception. This is an exceptional circumstance. However, I
to
mean,
speak about the case. What do you
yeah,
mean?
she's not to be talking to other people and not, your admonishment at the last hearing was that she wasn't to be communicating or talking about the case. So and she is in the middle of a cross-examination here. Admittedly,
Yes.
she is now without counsel.
Yes.
So I realize that it's kind of a catch-22. If she's going to hire somebody, she has to hire somebody to represent her. And are we going to place any limits on what she can do or what her counsel can do? This is new territory for me, so.
Well, I think what we'd have to do is have that counsel obtain the transcript from the last proceeding to get up to speed on where we were in the evidence, and then to be prepared with concluding this hearing. And of course, Ms. Mazzoni, that will require you to order the transcript or this new attorney to order the transcript so that we can proceed properly, because that would be the only way an attorney could prepare to go ahead and pick up where we left off. That would seem to me to be the proper procedural route. Ms. Donnie, do you have any objection to proceeding in that way? So we would need to strike next Tuesday. I would need to have Ms. Mazzoni, I would give her leave of court today to find new counsel, give her 21 days, because this was the first time it was brought to my attention that her attorney was suspended on Thursday, apparently. Ms. Mazzoni, did you know he had been suspended?
No.
Okay.
He's been suspended?
Yeah, he's been suspended from the practice of law. I was aware of the ARDC complaint against him, but he had not yet had discipline. So that's why, of course, we were allowed to proceed to hearing on the 25th and 26th.
Yeah, I didn't know about nothing. I just remember he was sick, and he told me at one time he was, at the day after court, he went to chemo, and after that I've been asking, I emailed him, I texted him, and the only thing I received from him is one email where Mary and the other lawyer, Hugh, emailed something to him, but not to me. I received only one email from him and nothing else after that. And I texted him and I called him. I asked, what are we gonna do? And there is no reply. And then the only reply I saw that he was really, really sick after chemo, and that's it. And I never heard, so I don't know what to do. That's why I filed my own motion, put question mark if I'm pro se or not, because I don't know what am I doing right now. But But in between this, you saying we haven't hearing on very subject, but while hearing is ongoing, I still have a court order that it's valid for me to see my son. So even if we haven't hearing on that, court order is still ongoing. So I don't understand why am I not seeing my son?
Because I believe there's a counter motion that you be suspended from any parenting time. Mr. Howard, you have your hand up.
I believe, Judge, that there was an attempt to make arrangements for a supervised visit. It's also my understanding that the supervisor is no longer willing to work with this case or is not available to work with this case. Insofar as communications for visits with the son or with the minor child are concerned, I don't believe there's a problem. It's just the problem now of finding somebody who will act as the supervisor. So insofar as that's concerned, I don't have, without prejudicing, doing this without prejudice and without waiving anything that we have on file with respect to terminating, a supervised visit would not be objectionable, but we need to make a formal arrangement. And I believe that, and without putting words into Ms. Donnie's mouth here, I believe that arrangements are being made or attempted and have been since the last hearing.
No, not true.
Ms.
Judge, if I may, I think you asked me a question. I'm just going to circle back. If I think it was whether I had any objection to the process of allowing Ms. Mazzoni 21 days to get a new lawyer, and subject to the previous orders and subject to her getting a transcript. It is unusual, but I respect that she's in a difficult situation. If she wants to get a lawyer, I would just ask that I would ask the court to put some tight timelines around this, because there have been many dates in which we're going to have a hearing and it got continued. And again, and you've looked at the pleadings, and something like this is extraordinary, but there was a pending ARDC complaint. Ms. Mazzoni knew of it. So, you know, it was not totally unexpected. However, this is difficult circumstances. But I would like to have tight timelines, because this is what has happened previously in the case, and it's not beneficial to the minor child. The second, in regard to the supervision, yeah, I mean, there were 2 dates that were provided from the last order with Judge Dickler. Those 2 dates, it didn't happen right on the dates, but there were 2 visits. What we've done is communications have gone through Mr. Bush versus Ms. Mazzoni for a number of reasons. And so with Mr. Bush out of the picture, we need to get Ms. Mazzoni, to allow us to be able to talk to her, send the emails directly to her in order to arrange additional supervised visits. As you know, Jesse Blanco was the one doing them. It's logistically just trying to figure out what days he's available, and what days that the child and Ms. Mazzoni are available. And so we're also trying to work with somebody else. He has Luis Sanchez is with the organization also. So if Jesse can't do it, possibly Louis could. And so we've been trying to do those. At this point, if Ms. Mazzoni is agreeing that she has her supplemental appearance and we can contact her directly, then we will contact her directly, so in order to try to arrange some additional visits with either Jesse Blanco or, someone from his organization.
Okay.
That's our goal.
Okay. So Ms. Mazzoni, you've raised your hand.
Yes. I wanted to say that Jesse never said to anybody, including me, that he doesn't want to be a supervisor. So that whatever Hugh Howard is saying is not true, absolutely not true. Where is any message or email showing that? Please show it to us in order for you to just say that in your words. Show the evidence. Jesse never said that to me. Number one. Number two, I have a letter from Jesse saying that my visits are very well. I can screen share it right now, and I'm asking to be able at least to talk to my son on the phone, because even that is being concealed. I am blocked from my son. This is improper. I never had anything that endanger my son in any way. There is no proof of anything, my son or my daughter. I don't know why I'm withheld from my kids for so long. This is court abuse. This is abuse. This is not normal.
Okay, thank you. Mr. Howard, you have your hand up.
Yes, Judge. Very quickly, it is well established in this proceeding that Ms. Mazzoni has a minor child's cell phone. It had been my intention to elicit testimony confirming this, but I will represent to the court that the child has his own cell phone. The child is 15 years old. If Ms. Mazzoni is calling him and he's not answering, we will take whatever steps are necessary without going to extremes to encourage the child to answer the phone. But I have to advise the court, this kid's in high school. He's very involved in high school athletics, club athletics, and he's got homework. So he's not going to pick up the phone every day when somebody calls. And like most high school kids, most kids his age, He's on his phone, probably playing video games or doing something else. So again, we will make every effort to encourage the boy to answer the phone. But the representation that she is not getting telephone time is simply misleading, and it is not true. With respect to Mr. Blanco, it was my understanding he was not available, and steps have been taken to arrange for a supervised visit. We would ask that Ms. Mazzoni provide her address to the court as to where she's living and what circumstance we are looking at here. I believe it would be just as before. They can go to lunch or dinner or whatever whenever the child is available. But again, I would like to remind the court that this boy is a premier high school athlete. He is involved in high school baseball, club baseball. He has a pretty tight and busy schedule. Nobody's hiding this child. Nobody's attempting to prevent this child from seeing anybody in a supervised setting. But it's a question of scheduling. And I think unfortunately, we have to live with that, and that's what we got. And
Okay.
so Ms. Mazzoni has to provide a schedule. We would ask that she provide her address. If she's asking that she see the child at her home, we want to know where she lives. I think.
Okay. So Ms. Mazzoni, you'll have to file a supplemental appearance now anyway, so that the attorneys can have direct contact with you. That appearance will require, of course, your address, your name, your address, your contact information. So you will need to do that so that the attorneys can have direct contact with you to schedule a supervised visit. And it sounds like if Mr. Blanco is not available, then his colleague Luis Sanchez would be available to serve as supervisor. So we just need to know your schedule. So we'll try to get that going. And the court will also grant you 21 days to find a new attorney. I will give new dates for the hearing. I had given you guys 2 dates last time. And do you think you still need 2 dates?
Your Honor, if Ms. Mazzoni is pro se, I think 2 dates might be optimistic, but that would just be my unsolicited opinion.
Okay. Ms. Mazzoni, you have your hand up again?
Yes. Again, Mr. Hugh is new on this case. He knows nothing about it. Judge Carr personally told Anthony to make sure that my son picks up the phone, and it's in a court order. And Judge Dickler, when she was there, she said that courts and practices and school is not priority when there is a visits with mom, and it has to happen. And Mr. Hugh keeps saying that, oh, he's busy, he's this, he's that. Well, for phone call, I think this is also a priority too. It's in the best interest of the kids to have relationship with both parents. So saying that he has a lot of practices and this and this and that is just an excuse, Mr. Hugh. And this is very poorly reflects on you, how you want to have my relationship with my child. So, and I do want him to reply to the phone call, and Judge Carr told Anthony straight that he needs to make sure my son picks up the phone call. And I just got text message from Jesse Blanco. He never said to anybody he doesn't want to be supervisor, ever, okay? So that is simply not true, Mr. Howard. So please stop lying.
I think they said he wasn't available and that perhaps his colleague, Luis Sanchez, could supervise.
He's available. He's available. It's just he needs proper notice, because those people never give proper notice. They give last minute, and he needs to have enough time.
Again, Ms. Mazzoni, they are going to try to find a date, but before they can even have direct communication with you to find a date that's going to work for supervised visit, you're going to have to file your supplemental appearance with the clerk's office. That supplemental appearance has your name, your address, your contact information, so your email, your telephone number. That's what an appearance is. So you have to get that on file so that they can have direct contact with you because you, according to the records of the court, you're represented by Mr. Bush. So,
I understand. Well,
have-
in order for me to have a phone call, I don't need to have a appearance. So that can be ongoing. It's not a big deal to have a phone call, right? I think it's very easy.
you need to have a supplemental appearance on file so that these lawyers can contact you. Otherwise, they're forbidden from contacting someone who is currently registered as a client of another attorney. Again,
so you're
those
telling
are
me that I cannot straight communicate to Mary? I
those
cannot.
are that's the code of professional conduct. You should get your supplemental appearance on file immediately if you want to see your child in a supervised setting so that they can make the arrangements with you directly instead of with Mr. Bush.
How about phone calls?
So again, you need to do that. You need to file your supplemental appearance so they can have direct contact with you. I'm not going to keep saying the same thing over and over again. Okay, so that's one thing for you, ma'am. You have 21 days from today until November 30th to retain new counsel. And again, that will be a hard stop because of the history of this case. I know that I heard some indication and read in some of the pleadings that you'd had something like 16 lawyers already. So we can't be abusive of the judicial process with delay. And of course, ma'am, you've already articulated here today that you don't want to delay because you would like to resume a relationship with your child. So you have 21 days until November 30th to retain new counsel. I am now going to look for a 2-day period when I could possibly hear this case thereafter. Counsel, please remind me, we're currently hearing one motion with, we're kind of, I think we took a couple of motions together, right?
Correct, Your
We
Honor.
took 3.
And we're in the process of cross-examination of Ms. Mazzone.
Correct.
And Mr. Howard, if I'm not mistaken, you've completed your cross.
Yes, ma'am.
Ms. Donnie's in the middle of her cross.
Correct.
Yes, ma'am.
Ms. Donnie, how much more time do you need to complete your cross?
I was thinking I would probably need about 45 minutes. I'm, just, yes, that's what I was thinking. 45 minutes to an hour. I say an hour.
Okay, an hour. And then Ms. Mazzone could be on redirect by someone or by herself.
Correct.
So a couple of hours to finish this. Then will there be another witness called?
Yes.
Ms. Mazzone, you would have another witness?
I have 3 witnesses.
And who are your other witnesses and have they been disclosed?
What does it mean disposed?
You have to disclose your witnesses to the other sides in case they want to take their depositions before they testify.
Oh, no, I don't know how that works, but I can tell you who I want to have as a witness and who agreed to be as a witness.
Did Mr. Bush disclose any witnesses, Ms. Donnie?
No.
Okay. We've already commenced the hearing, so I don't think there could be additional witnesses other than Mr. Mazzone. Is it anybody's intention to call Mr. Mazzone as a witness?
I guess, Judge, since we consolidated 3 motions, one of which is mine,
Yes,
Mr. Mazzoni's case in chief would require that I call him.
yes.
Again, procedurally, we started with Mr. Bush's motions, and then I guess that kind of left mine. Mr. Mazzoni's, I guess in rebuttal, Mr. Mazzoni's testimony could blend all of them. I would think his direct is pretty straightforward. I would think maybe 2 hours at most.
Okay.
But the problem I have here is if Ms. Mazzoni is representing herself, you can see where we might be going after that on cross.
Yes, it might take a while. Okay,
Well, I do need to bring witnesses because I believe representation from Mr. Bush last time was not proper. He was very sick. He was not prepared. I was not allowed to talk. And I wanted to bring witnesses. And I told him, but he was too sick. I even asked him, I said, Ted, why didn't you do that? Oh, I forget. I think when you do chemo, you don't remember things. Your brain doesn't work correctly. So everything, I put a motion in there to appeal last hearing because I don't believe that he was in his right mind. So I need witnesses.
Again, Your Honor, I'm going to object. We're straying off into the nether realms here of
That's not true.
hearsay and the like. I honestly, if Ms. Mazzoni has any problems with the orders that have been entered by this court, there are other remedies available to her. And when she gets her new attorney, she can explore those remedies. On the other hand, Judge, we need to move forward. And this is kind of a history in this case.
the only reason I'm trying to ask the questions is to figure out how much time I need to allow. I can allow a day and a half during the week of December 6th.
For the record, I note that I'm going to have an extended pretrial with Judge Goldfarb, I believe, on the 1st of December. So I'm going to be playing catch up on that. And I have another extended hearing with Judge Forty on the 29th of November. So if we're going into the week of the 6th, as far out as possible on that week would be best for me if we could.
Okay, so what are your conflicts the week of December 6th?
None, but I just need the prep time is what I'm asking the court for.
Sorry,
Okay.
I just scheduled a trial on the afternoon of this morning and the afternoon of December 6th. And then I'm available on the 7th, 9th, and 10th, not on the 8th.
What I would be looking at, the only days I have available that week would be the Tuesday, the 7th. I could allot that entire day, and I could allot the morning of the 9th.
I have
And-
those available. And Mr. Howard has those available too.
I guess that'll have to be, Judge.
Ms. Mazzoni, the day of the 7th and the morning of the 9th?
7 and 9. Well, like I said, that I don't know who is gonna represent me, so I don't know if this person is gonna be available. I wouldn't put it like that right now. I wouldn't, because I don't know who and when they are available. First of all, they
Okay.
need to learn the case. Like Mr. Hugh, he's new to the case. Whatever he's saying, it's like it's out of it, you know. He's trying
Again,
to stop my visits. That's ridiculous.
Personal attacks, Ms. Mazzoni, don't aid your case. You should really avoid personal attacks on lawyers. It's really uncouth. All right, so I could go into the week of the 20th of December.
Judge,
Right,
I'd rather, if we can do the 7th and 9th, you'll get me in the doghouse with my wife if we go into the 20th.
okay. The problem though is that Ms. Mazzoni's lawyer may just, if she gets somebody by the 30th, may not have the time to get the transcript and to figure out where the case sits and to be able to proceed on the 7th and 9th. So I'd rather give dates that would give that new counsel sufficient time to get up to speed to be able to represent her adequately. And I can't really,
Understood, Judge. It's fine. The week of the 20th.
yeah, I mean, if you guys can be flexible, I can give you some days in the week of the 13th. December 13th, if you can remain flexible.
I'm fine.
So the days I have available that week would be the 13th, 14th, and 17th. My preference would probably be the 13th and 14th. If you guys have those days available, December 13th and 14th.
Judge, I have a trial on the 13th. I have the 14th available. I have a status at 9:30. I'm on, it's a status. It would take 10 minutes, so.
Mhm.
And I do have the 17th available all day. It's Friday. So I have the 14th and the 17th.
Okay, what about that then, the 14th and 17th?
Fine with me, Judge.
Ms. Mazzoni?
What was the dates again?
December 14th and 17th.
It's like I said, first of all, thank you very much, Judge, that you understand my situation, that you've given me extra time despite them objecting on that, because you understand that lawyer needs to appear, he needs to learn the case is long. Thank you very much for that help. So 14 and 17, I can't say I am available, but I will have to find somebody who has to learn the case, and I don't know how that. Let's say that the lawyer is not available on 14th and 17th. What do I do then? I mean, he probably will communicate to, or I don't know. Honestly, I don't know.
He or she would have to file a motion.
Okay. But
Yeah.
in time of availability for another person that I don't even know, I can't say that. I know I am available.
Okay, so we'll go with December 14th, starting at 10 a.m., Ms. Donnie?
Yes, that would be great. I appreciate the accommodation.
10 a.m. on the 14th on Mazzoni, 9:30 a.m. on the 17th. And there is a chance that on the 14th, I'll have to be gone for part of that time. I am managing a campaign for myself for the appellate court, and I will be given a slating. And I'm not at the courthouse right now, so I'm at my home. I can say this out loud, that I will be given a slating interview time on either the 13th or 14th, and that has not been given to me yet. I'm hoping it'll be on the 13th, and that way we won't have any conflict whatsoever. But I do have to appear before the party for slating on one of those 2 days, but they haven't given me my date or time. So that's why I'm indicating that I may need some flexibility, and I can, let you guys know if that's going to be an issue. But for now, I'm going to put you down for December 14th at 10 a.m. start, December 17th for 9:30 a.m. start. Ms. Mazzoni, I have indicated to you a few times what you'll be required to do. You should immediately file a supplemental appearance in this case with the clerk's office and serve that upon the attorneys via email.
And it has to be file stamped as well?
Yes, it will be file stamped. Yep. And I'm giving you leave of court to do that in today's order so that you don't have to file a motion for leave to file a supplemental appearance. Do you understand?
So just, there is a form it called appearance, right? That's the only thing I have to do and send it
Yes.
to them.
And I don't know if it's a separate form for a supplemental appearance, but you can write that word on there so that the clerk knows they shouldn't charge you any fee because you've already paid the appearance fee through counsel.
Actually, Judge, I have a $298, so I don't pay.
Okay. So if there's a $298 on file for you, then it's just basically filing the supplemental appearance so that these attorneys will have a direct contact with you. You serve that again on the attorneys and on NYRE, so I know you're officially in the case now. You are given 21 days to retain new counsel until the last day of this month, November 30th. I've set the new dates for hearing. And I don't think there's anything more at this time. Ms. Donnie, do you know of anything more at this time that the court needs to
No, Your Honor, but I know that to speed things up, if Ms. Mazzoni wants to order the transcripts, you've had official court reporters here, she can do that immediately, and then get the court reporter working on the transcripts, if she, once she gets her, to get it going, so if she does want those transcripts.
Do you have the phone number handy for the official court reporter? And Ms. Barb, do you know who it was that this would have been? I don't remember the court reporter's name.
I do have that information, Judge. You want me to state it out loud? Do you want me to put it in the chat? What's your preference?
Ms. Mazzoni, how do you wish for that information?
If you just put it in the chat, that would be awesome. Thank you.
Okay, but I can't take down what you're saying and put it in the chat at the same time. So if you give me a second.
Your Honor, I'll be happy to put it in a chat right now. If the court reporter would kindly.
She can't take down here what you're saying, so just hold on for a minute.
May I ask the court reporter to also add the address of the court reporter's office so that Ms. Mazzoni has the ability to go and pick up the transcript physically?
They can be emailed to me. I don't need to go physically. We're in 21st
They don't
century.
email them. They don't email them. You have to pick it up, Ms. Mazzoni.
That's not true. I've been emailed many transcripts. It's 21st century, Mr. Hugh.
Okay, Ms. Mazzoni, are you in the chat? Do you have the information?
Yes, I see, but I don't know if it's gonna stay once I go. I need to, I guess.
You'll need to write it down right now.
Picture of it.
Or take a screenshot, whatever you need to do. But you'll see the phone number is there, the court reporter's names. That you'll need that when you order the transcript. And then that's the address for picking up the transcripts.
Okay, so they cannot email it to me?
I don't know. You'll have to talk to them about that. But that address is directly across the street from the courthouse.
Okay.
Okay.
And why do I need to do it now?
The whole idea is that so your new attorney can hit the ground running. There will be no way for the attorney to know what the scope of the examination was without reading the transcript. So that way, if you get the transcripts and you hire your lawyer, you immediately give the transcripts to your lawyer because it could take the court reporter many days to prepare the transcript.
Okay, so I will call them.
That way we'll be ready to proceed on the 14th.
Okay, I'll call them. Is there a fee that I have to pay for that, or because I'm 298? I don't know how it works.
You would have to give them proof of a 298 order. And then I do think that the transcript is free. Is that right, Ms. Barb?
As long as Ms. Mazzoni provides the 298 order, yes.
Yes.
Yes, I have it. Yeah, that's fine. The only thing, like I said, the main thing here, I understand your procedures, you're the judge, you're the lawyers, you have your procedures. But my main concern is my child. I wanted to see him, I wanted to talk to him. And it's very easy, at least, to have a phone call in between that, Very easy for Mr. Mazzoni to tell my son, as been said by Judge Dickler and by Judge Carr, that he needs to tell him to pick up the phone. And I don't understand why Mary is not insisting on that. She's a kid's attorney. She's supposed to be.
It's hard to deal with. It's hard to deal with teenagers. I have one of my own. Again, I would restate what apparently Judge Carr and Judge Dickler indicated, and that was that Mr. Mazzoni should use every effort to encourage his son to pick up the phone when he's getting a call from his mother. And again, Ms. Mazzoni, with your supplemental appearance on file and served on counsel, they'll be able to contact you directly in order to arrange for supervised visits with either Jesse Blanco or Louis Sanchez. And again, I would also encourage that between now and December 14th. I think we've completed everything we need to do today, unless one of the attorneys has any additional questions. Ms. Mazzoni, I think you understand what I'm expecting of you between now and the 14th. So I'll just wish you guys a good day, and I'll be seeing you again on December the 14th.
All right. Thank you, Your Honor.
Judge.
Thank you, Judge.
Good luck to you all. Bye now.
Thank you, Your Honor.